You know, yeah. We are ready on minus.
Okay, so this is case number 25S01096 People of the State of Michigan versus Athena Kimei Miles.
Brittany Rose on behalf of people.
All right.
Colin McLaughlin, piece of front door, 6 on behalf of Ms. Miles, Ms. Miles, the state manager.
Atiana.
How do you pronounce that?
Atiana.
Atiana? Okay, let me phonetically write that. Atiana. Okay, so Miss Atiana Kimei Miles. All right, and so we're here today for trial on this charge of intentionally threatened to commit an act of violence against the school employees, or students. And were there any preliminary matters?
The only preliminary matter, Judge, from me is that there was an offer in this case that Ms. Miles would be, if she pled guilty, it sounds like there'd be a killable to fines and costs in this matter. I'm not guilty plea charge. I did discuss that with Ms. Miles extensively. I've explained to her repeatedly, and my understanding, Ms. Miles had no interest in that. Is that correct, Ms. Miles? I just want to make sure for the record that that's true.
Yes.
Okay.
Okay. All right.
And from the people, Your Honor, we would just ask for an order of sequestration,
All right.
including the OIC in this matter, who is seated to my left. Additionally, I've had the opportunity to speak with Mr. McLaughlin about people's exhibits. We have 4. I believe we will be admitting those via stipulation. I can describe those for the court.
All right, so you have some stipulations. You wanted to put those on the record?
Yeah, 4 exhibits, the people do, Your Honor, and we are admitting those by stipulation. That's the end of attack. So people's exhibit 1 will be school photo 1. People's exhibit 2 will be school photo 2.
Yeah, it's fine. Okay, you're welcome.
People's exhibit 3
Oh,
will be face sheet,
I'm sure they are.
and people's exhibit 4 will be officer swope body worn camera from the beginning until the 5-minute and 4-second mark.
Beginning until 5 seconds?
5-minute and 4 seconds.
Oh, 5 minutes and 4 seconds. Okay. All right, so that's the stipulation for those facts.
You don't want to say.
And the court will grant that motion for sequestration. We'll make it a mutual sequestration. So if anybody comes in, we'll ask them to not discuss the case and step outside.
For the record, Judge, Ms. Miles' boyfriend is in the courtroom. He's now with us.
Yeah, he can stay. Okay, other than that, anything else? We went over the instruction. That was good. Let's see. I think we're all set for, at least for now. Okay, bring them in. All right, everyone may be seated. Well, good morning, ladies and gentlemen. Good morning. And I'd like to welcome you here to your jury service at the 46th District Court. I'm Chief Judge Sheila Johnson. And it's really an honor and privilege to have you here today. I know that for many of you, jury service might be a very new experience, and some of you are sort of seasoned with it. But know that jury service is one of the most serious duties that members of our free society are asked to perform. Our system of self-government could not exist without it. So the jury is a very important part of this court, and the right to a jury trial is an ancient tradition and part of our heritage as a country. The law says that both a person who is accused of a crime in this case and the prosecution have the right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias or prejudice or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. And a trial begins with a jury selection process. So the purpose of this process is to obtain information about you that will help us choose that fair and impartial jury to hear this case. During the jury selection process, the lawyers, and sometimes I, are going to ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defense, the defendant, or any other witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified to serve as a juror. These questions may probe deeply into your attitudes and your beliefs and your experiences. They're not meant to be an unreasonable prying into your private life. However, the law does require that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, then you should say so. If you do understand it, then you should answer it truthfully and completely. Please do not hesitate to speak freely about anything that you believe we should know. Now, during this jury selection process, you may be excused from serving on the jury in one of two ways. First, I may excuse you for cause. So that means that I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a peremptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. So before we get started, I'm going to ask you all to stand and to swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as jurors in this case. Now, if you have religious beliefs against taking an oath, then you may affirm that you will answer all the questions truthfully, fully, and honestly. Madam Clerk, raise your right hands, please.
Do you solemnly swear or affirm that you will answer truthfully and completely all questions about your qualification to serve as jurors in this case?
All right, thank you so much. You can have a seat. Well, since we will be prying just a little bit into your private lives today, I thought it's only fair that we introduce ourselves to you so you know a little bit about us as well. So, of course, I've introduced myself. I'm Judge Sheila Johnson. And of course, my job in this particular case is to just make sure that the trial goes smoothly and fairly and to rule on any objections and evidentiary issues. So we have over here to my right, this, you may have just met him. This is our court officer, Charles McClanahan. He has a couple hats. Today, his biggest hat is taking care of you. So he will be the person that is your connection to me and what's going on here. So he's going to keep you sequestered back in your jury place once you're selected. He's going to make sure that he, takes notes from you back to the court and otherwise make sure that your needs are met. Obviously, he's a big guy and he's security too. So if anything breaks out in the courtroom, we try to keep some tact and decorum here, but sometimes people get a little upset about different things. So his job is to just make sure that we're safe and that he quells any disturbances that might be going on here. All right. So, and also, he checks people in and does things like that to make sure that we have everything in order when we start our dockets. So, he's sitting at a desk. I guess it's his desk now, but it used to be the court reporter desk. So, the person that you see typing the keys, well, we don't have one of those anymore. Unfortunately, times have taken its toll on that job. And so we do have a camera system, which I prefer the court reporter myself, but we do have this system and you'll see cameras up here. So we can get a view of everything that's going on from the audience and the podium to counsel, to me, to the witness, as well as there's sound connected to it. So if we wanted to get a transcript, which is the official record of the court, we still have to use a court reporter, a person who is used to reading the recordings and transcribing. So that would still be the official transcript of the court. So we have to my left, which I have these big screens now, so I really can't see her, but she's over there. That's Miss Jessica Liddell, and she is my judicial assistant. And so she has one of the bigger hats, might even be bigger than mine in a sense, because she has to keep our docket moving. So she's got to know what's going on with pretty much every case that we have, whether it's criminal, whether it's civil. She answers phone calls from the general public, from lawyers. She schedules hearings on things, motions, trials, answers the phone, deals with me, my requests, anything else that we have to do, prepares, jury instructions, verdict forms, whatever we need, she gets done. So she's usually quite busy. And her job here today, she's going to be just keeping track of a few things that are going on with respect to the jury trial. So that's pretty much is our full staff. It's small but mighty. And so, and we work pretty well together. So that's who we are. So now we're going to introduce the parties to the case. So, of course, today you're going to be hearing a criminal case, and this is involving this charge of intentionally threatening to commit an act of violence against a school or school employees or students. All right. And so this charge, I'm going to explain it to you a little bit more fully later. But it's been made against the defendant, who is Ms. Atina. I think I pronounced it right. Let me make sure. Yeah, Atiana. I'm sorry. Ms. Atiana Kime Miles. And the defendant's lawyer is Mr. Colin McLaughlin. So first, I'm going to ask Mr. McLaughlin to stand and introduce his client and any other persons that he may wish to introduce at this time.
Sure. Good morning, everyone. Representative Ms. Miles, you stand up. This is my client, Ms. Tatiana Miles, who I'll be representing today. In addition, Judge, would the court like me to read the list of witnesses?
Yeah, we might as well while you're at it.
Potential witnesses we may call in this case include Ms. Miles, and also Tanisha Bogan, Andrea Cobb, Paul Siebert, Andrea Morris, and Azaria Stevens.
All right. And then the lawyer representing the people of the state of Michigan is our assistant prosecuting attorney, Ms. Courtney Rosenau. We're going to ask her to stand and introduce persons at her counsel table and any witnesses that she may be calling.
Thank you, Erica. Thank you, everyone, for being here this morning. I know you're required to be here, but I want to start by thanking you for your time. As the judge said, my name is Courtney Rosenau. I represent the people of the state of Michigan in the Oakland County Prosecutor's Office. Seated to my right here is Detective Jadovich, the detective with the Southfield Police Department. She'll be testifying today, but she is here overseeing the case of the officer in charge. I do plan to call a few witnesses today by the names of Miss Thessalonía Tansel, Miss Kimberly Pritchett, Mr. Matthew Knox, and then Officer Spence and Officer Chandler, who are officers with the Southfield Police Department. Thank you.
Okay, thank you very much. So I'm going to be asking you if anyone knows any of the witnesses that were listed by any of the parties to this case, or if you think you know the defendant, or if you think you know either one of the lawyers. So if you raise your hand now, and if you're seated, we're going to go further into it. All right. So no one appears to know anyone else. Okay.
Yes.
Oh, yes. Oh, yes, sir. Yes. What's your name?
Dave Lauer, we may have had a traffic violation of Officer Chandler, 696 in Southfield, approximately 6 years ago. I'm not sure though.
Oh, you remembered it? Oh, that's wonderful. Now, did you know the officer prior to that?
I know, I have close associates that know Officer Chandler.
Okay, now what we're going to do is if you're seated and calm, we're going to ask you some more questions about that. Okay, thank you so much, Mr. Lauer. Okay. So this is a criminal case, and the paper used to charge the defendant with a crime is called a complaint. Now, the complaint in this case charges the defendant, Ms. Atiana Kime Miles, with one count of the crime of intentionally threatening to commit an act of violence against a school employee, or students. And it reads as follows. In the city of Southfield, on or about October 24th of 2025, the defendant, Ms. Atiana Kime Miles, contrary to law, did verbally, through the use of an electronic device or system, or through other means, intentionally threaten to use a firearm to commit an act of violence against any school, employee on school grounds and or school property, and the threat can reasonably be interpreted to be harmful or adverse to human life or dangerous to human life. Now, you should know that the defendant has pled not guilty to this charge. You should clearly understand that the complaint that I have just read is not evidence. A complaint is read in every criminal trial so that the defendant and the jury can hear the charges. You must not think it is evidence of her guilt, or that she must be guilty because she has been charged. Now, we think that this trial will last for one day, but in any event, no more than probably a day and a half. If you believe that the length of the trial will be a real hardship for you, then please let me know when you're seated in the jury box. And before, let me read this one thing and then I'm going to start seating you. Some of you could have some health problems, of course, that might prevent you from serving as a juror. For example, you could have a medical problem that makes you unable to sit for 2 or 3 hours at a time, or you might have a sight or a hearing problem, or maybe you're diabetic and you need to take more frequent breaks to get some juice or get a snack or something like that, or you have to take more frequent restroom breaks due to whatever reason. We're here to try to accommodate those things for you. If you have a language barrier or if you have a loss of hearing, then you need to let us know about any issues like that once you're called up to the jury box, and we can see if it's going to bar you, if we can accommodate you. Okay. So before I continue on, I'm going to read, I said one more thing. I'm going to read one more thing and then we're going to select you. So you need to know that a person accused of a crime is presumed to be innocent. So this means that you start, and you must start, with the presumption that the defendant is innocent. Now, this presumption continues throughout the whole trial and entitles the defendant to a verdict of not guilty, unless you are satisfied beyond a reasonable doubt that she is guilty. Now, every crime is made up of parts called elements, and the prosecutor here must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. So if you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or the lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that's reasonable after a careful and considered examination of facts and circumstances of the case. Now, of course, I will be adding additional instructions as we go along, but those are some preliminary ones to get us started and to get you seated. So the process here, we're going to call you up and ask you to sit in the numbered seats. Number 1's the one closest in. Number 7 is the one furthest in. So when you hear your name, you're going to come, or your juror number, you're going to come up and walk in and have a seat there. If for whatever reason you may be selected off, then of course you'll vacate your chair, come back, have a seat in the audience, and we're going to call the very next person in line to come and sit in that empty seat. And we'll do that until we have selected our jury panel for the day. Okay? So this process, we don't really know your order. We get that from the state records, driver's license, state IDs, voter registration rolls from the county. It's pre-selected randomly by computer. So this is what I got, and this is how I'm going to call them. Okay. So, and we'll take just a little volume off while we call your name.
Alluded to some previous experience, and as Judge Johnson said, we start off with this cloak of innocence, and I have to prove all 5 elements beyond a reasonable doubt. It's really important that you hold me to my burden. It's very important in our criminal justice system and the Constitution that is the standard by which I have to prove a crime occurred. But I'd like to ask you if you're willing to share your past experience so that we can get an idea of where you were coming from with your statements earlier.
Or just from the people. We get arrested, we get arrested, they all night, they get locked up. Can't afford bail, they're locked up until you get out. So essentially, you're guilty until you're full innocent.
Is that something that you went through personally or maybe somebody that you
My
knew?
brothers, most of the people I know.
Okay. So do you,
I was found innocent on the charges, but I had to stay locked up until I was found innocent. Not till I was proven guilty.
okay. So if I'm hearing you correctly, you were arrested for something you didn't do and it was later proven, but you still had to spend that time.
Correct. I couldn't afford bail,
Okay.
but I was innocent. I didn't do this. I know you did it. You're getting locked up until you can prove you're innocent.
Do you think, based on the judge's instruction and anything else that you might hear from us, if we tell you that we start with,
I get it. I know what you're saying, and I'm going to this new experience. I am willing to try to listen to it, but from my past experiences, or my experience, I was guilty until I proved myself guilty.
so if you go back into the jury room, are you going to try to bring that into the
No,
jury?
I wouldn't do that. I would just letting you know from my experience. That has nothing to do with this.
Okay, and that's fair, and I really respect that. Thank you for bringing that to our attention. Do you think maybe it would have the opposite effect, that even if I did prove my burden beyond a reasonable doubt for each of those elements, that you wouldn't be able to convict because of your own experience? Probably. So you don't believe that you would be able to be fair and impartial in that way?
I don't know. I would have to hear the evidence.
Okay. But it would probably be harder for me to prove to you, I guess, as opposed to other people who haven't had your experience.
Definitely.
Okay. Now I'd like to just go through a couple more things. After we have determined who will sit on the final jury for this case, and before we start hearing the evidence, Judge Johnson is going to read you some additional instructions. One of those instructions is entitled Duties of Judge and Jury. So part of that instruction states that it's your job to decide what the facts are in this case, and you must apply the facts to the law as Judge Johnson gives it to you. It's Judge Johnson's duty to instruct you on the law, and you must take the law as the judge gives it to you. Does everyone understand how important their job is here today for both the people of the state of Michigan and for the defendant? Does everyone agree to follow the law as the judge gives it to you? Is there anyone here who, if chosen as a juror, would find the defendant guilty or not guilty just because of your own beliefs about the criminal justice system? Anyone? Raise your hand if you think that you would be able to make that decision just based on your own beliefs about the system, or about police officers, or about the way cases are charged and prosecuted.
How did you pose that question?
Yeah, so my question is, do you think that you would find the defendant either guilty or not guilty, just based on your own beliefs about the criminal justice system? No? Did you want to share something additional about that? Okay, just, if you do, if anybody has more additional information to offer in response to one of my questions, please just raise your hand, because we're here to hear from you. Now, how about the fact that this case is about a threat against a school? I know this might be sensitive for some people. As the judge already said, the case is about a threat to use a firearm to commit an act of violence at the school. That's the statute up there on the screen. This is the relevant portion of the law. So what this case is about the threat. What this case is not about is an actual school shooting, or even about steps taken to carry out that threat. That being said, does anybody think just the nature of the case itself would be too upsetting to them, and Judge Johnson touched on this, that you wouldn't be able to hear the evidence and give a fair verdict? Everybody can be fair? Has anyone themselves, or maybe your child or someone that you know, had an experience with a threat to a school or a lockdown? Anyone?
Hold that thought.
Yes, you have. Well,
We don't know who he is. You gotta wait. Wait till he gets seated. Hold that thought and tell us when you get seated up here.
In terms of like not elementary, middle, high school shooting, but my brother was, currently going to school looking at Michigan State campus right there, active shooter.
And you,
He was safe. He was not like in any of the buildings or anything happened. He was safe the whole time. We were in contact with him. That's my only.
thank you for sharing that. Does your brother's experience and any communications that,
Facts.
you already see where I'm going?
Yeah, yes, yeah.
Yeah, we're trying to seek that fair and impartial jury. Now, if somebody makes a threat towards a school, is there anybody here that thinks the police should ignore it unless there's some sort of evidence that that person was gonna carry out the threat? So just the threat itself, is there anybody that believes that that should not be done? Does anybody have an idea on why the Michigan legislature may have made it a crime to threaten a school? Just anybody that could offer an idea? Yes.
Perhaps because of the insurance that are coming, they'll try to intercept that and it happens. So in the thread is and
Sure, yeah. Anybody else have an idea about why this might have been important enough to write into the law? Ms. Williams? No? So it's a serious thing when people threaten schools, right? Because we don't know if that threat is going to be carried out or not. Would everybody agree with me that it takes a certain amount of police resources to respond to a threat that otherwise might be better served out in the community doing something else? And when somebody makes a threat towards a school and it turns out that nothing happens afterwards, can anybody think of some things that might happen in the school as a result of the threat? Anybody familiar with school procedures or what you imagine might happen if a threat is voiced?
School would go into lockdown, depending on when the threat was intercepted, what time of day, or when children actively at the school. This threat happened. Did the threat involve anything in particular? Were they threatening a certain building within a school district, a certain person, student that would play into it? After the threat, I guess, depending on school and resources, is there extra security measures? Are there, do you need to talk to, like, when my daughter is the active shooter drills at school, like, they let parents know, so if she comes out and asks questions, we can respond as parents and like learn how to talk to her about it. I'm sure those types of things happen in that situation.
Sure, yeah, good answer. So in that situation, even if it was later proven that the person did not intend to carry out the threat, does everybody agree with me that there could still be some repercussions or consequences as a result of a threat that might even be an empty threat? Is there anybody that disagrees with that statement? Has anybody ever heard someone say something that they later claimed was just a joke or they didn't mean it? Anybody? Anybody ever gotten that or said that to somebody before? Maybe you accidentally offended someone and it's just a joke. Would everyone agree that sometimes it's the impact of that statement on the person who hears it that's more important rather than what your intent was? Fair statement? We're talking a lot about things that were said. So I know Ms. Williams, I know you've got this, but is there anybody who's thinking about freedom of speech and how that is impacted by all of this? Anyone? So the freedom of speech is a constitutional right, obviously, that guarantees our right to free speech. But would everyone agree with me that that's a legal concept and that there are probably different directions that courts have given us about what's acceptable and what's not acceptable and what constitutes free speech? Is that a fair statement? Does everybody agree with me that it would be a question of law about whether this law violates free speech? And that would be up to Judge Johnson or another judge to decide if it is impacted. Does everybody agree with me about that? So if the judge tells you you're the judges of the facts, would everybody be able to apply the facts to this law? Yes, I'm seeing some head nods. If you just nod or shake your head, then I don't have to call you out. I'd like to talk about sympathy. It's a common human emotion that we all have. And you might feel bad for the person that's sitting here being accused of a crime. Does everybody agree that you cannot let that affect your verdict? So the judge is going to tell you what the elements of this crime are, and the judge is going to tell you that I need to prove each of those beyond a reasonable doubt. Ms. Miles looks like a really nice person, but anybody going to hold it either for the defense or against the defense, just saying, I feel bad that she's in this situation. Does anybody feel that way?
Okay. What's your name?
What about if you really agree with the reason that somebody might be mad? You really agree that if this happened, I would be really mad. Would you still be able to sit and listen to the evidence today and apply that evidence to the law and think about whether I've met my burden beyond a reasonable doubt, just based on the evidence that's come in, and not be sympathetic if there's maybe a reason behind why something happened?
Oh, if I'm Saturday.
Does anybody have an issue setting aside sympathy
I don't know.
in this situation?
Your name? Mhm.
So, Mr. Littlejohn. Miss Littlejohn, I'm sorry, Miss Littlejohn, I was confusing you with the man next to you. If the evidence comes out and you really feel very sympathetic towards the defendant because of what caused everything to happen, would you still hold me to my burden and be able to look at the evidence as it applies to the law?
Uh-huh. Bye-bye.
And that's the same for you, Mr. Whitson? Now, in Michigan, the jury does not decide the issue of a sentence. That's left up to the judge. The juries only decide whether the person who is charged is guilty of the crime charged. So when the judge, if there's a conviction, it would be up to Judge Johnson to look at things that are in the defendant's background, maybe hear from any of the people involved in the case. And then she would make her decision based on things that you won't even know about. And the judge can take into consideration good things and maybe not so good things. Does everybody understand these rules? Does anybody have an issue setting aside what the penalty might be if you were to convict? Anybody worried so much about the penalty that they would not be able to be fair and impartial? Now, I'd like to talk briefly about the burden of proof, which is beyond a reasonable doubt. And Judge Johnson is going to instruct you, and she did already, that as the defendant sits here today, she's presumed innocent, and I have the burden of proving guilt beyond a reasonable doubt, and that the defendant does not have to do anything. I know Judge Johnson already read this to you, but I'm more of a visual person, so I always like to put this up on the screen so that everybody knows exactly what the burden of proof is and what it isn't. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Does everybody agree to hold me to that standard? Does everybody agree not to hold me to a higher standard? Because proof beyond a reasonable doubt does not mean proof beyond all doubt. It doesn't mean there's zero doubt or proof beyond a shadow of a doubt. That doubt must be reasonable for you to not. That doubt must be reasonable. In life, would you agree with me that there's always some doubt unless you witness something yourself? For the most part, right? Like, you can understand that something happened out there, but unless you witnessed it yourself, you don't know absolutely for sure. Is that a fair statement? So, but would everybody agree with me that if you were to see a crime happen, that you would probably be called as a witness in the case and not be sitting on the jury? And does everybody understand and agree that proof beyond a reasonable doubt is the same standard in all cases? So from the most minor criminal case up to a homicide, it's proof beyond a reasonable doubt. Everybody understand that? And does everybody agree with me that if the standard were to prove beyond all possible doubt, that we probably would not have very many people convicted of crimes, even for big crimes like murder? Is that a fair statement? Does anybody have any questions about this for myself or for the judge or for defense counsel? Now, the way that the people will seek to prove this case beyond a reasonable doubt is through evidence. When you hear about a criminal case, what kinds of evidence do you usually expect to see? And I will start with you, Ms. Pritchard. What sort of evidence do you expect to see in a criminal case? If you can anybody think of some types of evidence that might come out in a courtroom to prove a crime? Yes. Right, so verbal would be testimony, would be witness testimony, right? And that's included there in the definition of what evidence is. What about photographs? Video? Anything like that? Maybe maps, depending on what the crime is and what people are trying to tell you about? Is that fair? No? Yes.
Somebody's attention. Is it okay if I use the restroom?
Yes, ma'am, you can step out. Go ahead.
I'm sorry,
Several of us.
Okay, what we'll have to do, where's the court office?
right here.
We'll have to get him, hold on. They want to take a 5-minute break for a restroom, so you're gonna have to escort them.
Are we just all of us?
Yeah, but it's all gonna break. Okay.
All right.
Okay, the record should reflect at this moment that the jury panel is outside the courtroom.
One juror still present. Oh, I have to be there.
No, we're just gonna take a recess.
No worries. Okay. All right. You're welcome. You're welcome. Bye-bye. You still muted, Jim? Oh, wait, not you.
All right, everybody may be seated. All right, the record should reflect that now each of our jurors, prospective jurors, I should say, are back in the courtroom, and the 7 that are currently impaneled in the jury seats are currently present here. My understanding is that when we did break for the restroom break, we did have one prospective juror that did remain in the courtroom, and the court officer probably should have taken everyone to the restroom break, but I understand that there was one person left with one other person that was in the courtroom, but my understanding is there was nothing said to anybody by any family member or other observing parties
Oh, this is.
to this juror. So, ma'am, is that true? Okay, all right.
Oh, she may have gotten me found.
Okay, so when we took our recess, we did have these 7 jurors impaneled, and Ms. Rosenau was finishing up on her verdict.
No worries.
Yes, Sharon, thank you. Just a couple more questions. Thanks for being patient with me through this process. Everybody agrees to hold me to my burden, right? And just one last thing I wanted to touch on. Would everybody agree with me that we are in the 46th district court? We're not on Law and Order. Is that a fair statement? If I'm able to prove my case beyond a reasonable doubt, but I don't have lights and sirens and nobody's bursting into the courtroom, are you going to hold it against me? Right. I'm asking for a fair verdict based on the evidence. Is everybody okay with that? All right. I have no further questions.
Okay, Ms. McLaughlin.
Good morning, good afternoon now. Good afternoon, everybody. How are you? I just have a few follow-up questions, based on, everyone's pretty well covered. It's pretty well covered. So I'm pretty well covered. Ms. Brax, I just got to be blunt with you. You got 2 young kids. I got 2 myself. I got 4 2-year-olds. I get you. I just want to know, do you think this is the right jury for you? If you were in my client's seat, would you want yourself on the jury?
No.
Okay, fair enough.
Yeah,
I appreciate that.
Yeah.
Miss Williams, you're far more educated in these matters than most of the people in this room. So, I think that can be good at that sometimes. You have experience. I'm glad you said so. Can ask people with this transport insurance. It sounds like the city attorney's office is part of that.
Well, no, I didn't. It's outside counsel.
Okay, if you're outside counsel. It'd be fair to say do you deal with like prosecutions of like ticket?
No,
Okay.
so for example, if the officers were involved in shooting and it was alleged that it was, that was, I live represent the officers and that
Maybe just to put it on your calendar, just to remind you. She said she needs you to confirm by Friday.
it wasn't just officers. I mean, I was outside counsel for the city, but some of them did involve.
It would be fair to say, having dealt with it, how long have you dealt with property?
Harmony?
How long did you do that role for?
Probably 15.
You've dealt with a lot of claims, a lot of statements, a lot of incidents that occurred in that, right?
Yes.
And it'd be fair to say the experience as an attorney, you after being an experienced attorney, you probably had a lot of reports come in that, you learned later there was more than that. Yeah. Right. Okay, so that does happen, right? You get stories and the stories turn out to be a little bit different, right? And you would obviously, given your experience, keep an open mind in this case. Anything about your experiences you think you want to be a jury, or would you get fair jury?
I wish I could say yes, that there was, but there is.
Okay, fair enough. I know you're not super anxious to be here. I get that. None of you are. But I appreciate that. Ms. Rosenau touched a little bit about, this is a weird case because this involves speech, right? We have a First Amendment in this country. Like we're one of the few countries in the world that allow the openness of speech that we have, right? And a lot of other countries have more restricted policies, for example. And this is one of the few times in the law that there is a crime that is basically speech driven. You can say something and it's a crime. It doesn't happen. And what I'm getting at here is I want to know, I personally am like a big free speech guy, and I like anytime you start criminalizing speech, I get really nervous about it. So I personally wouldn't be like a great juror. Probably. Does anyone else feel that way? Like either that way or even in the opposite direction? Like for example, the United Kingdom, they have like very strict speech law. You can violate the law by saying possible. And if you feel that way, that's okay. I just want to know. Does anyone feel like you'll be treated more crimes based on what you say? If you do it, okay, Mr. Well, no, British will speak. Okay. That's it. Mr. Ridson, how do you feel about that? I'm sorry?
But I don't think I'm part of this free speech as well.
Yeah. Anyone else feel like, does everyone feel like kind of we got it right in this country, so to speak, in this little town? You think that?
If the law has been established, you have to follow it.
Fair enough. Bridget? We got it about right?
Yeah.
Okay, fair enough. Okay, anyone else? The judge went at length, and Ms. Rosenau went at length about what beyond a reasonable doubt is, either the whole instruction authority of emergency. If anyone disagree with that? Anyone have any feeling about that? Mr. Russell, obviously, we prefer you feeling about it. If you agree with that standard, obviously, right? Okay. Okay, is there anything, this is the time now, if there's anything we didn't cover that you think we should know about, because you're just not the right juror for this jury, now's the time. Anyone else have anything? Okay, I appreciate it, thank you.
All right, thank you. So, Ms. Rosenau, challenges for cause.
Yes, people would like to thank and excuse jurors.
Cause.
Oh, no, not for cause, Your Honor, sorry.
Okay, any cause for you?
No.
All right, that's her peremptory number 7.
Thank you.
Okay. To replace juror on seat number 7, number 8, Mr. Lahr, David Lahr. All right, tell us a little bit about yourself and your family.
Single, long-term partner. Live in the area and district. I work as a political candidate for HD6.
What's HD6?
This district.
Oh, okay. Mhm.
I've got 2 precincts in Southfield. I was finance before that, camp for at-risk youth. A lot of different things, a lot of philanthropic and nonprofit work as well.
Okay, what does your significant other do?
She's always helped manage our business. She is our campaign manager currently.
Okay, wonderful. All right, well, you told us a little bit about a run-in with a police officer. What is that all about?
That was just a routine traffic violation. Was the no turn on red, Southfield 696. I believe it was Officer Chandler. Not 100% sure. There could be more than one Officer Chandler. I do have close friends that know him well and family in the Lathrop Village area.
All right. Was it a Lathrop? It was 696. It would have been Southfield officer.
That's correct. They also have a family business in Southfield.
Okay. And so, was there anything about the fact you got stopped by the officer at that location that makes you feel that you disbelieve police officers or question them, or?
Not in that particular instance, Your Honor, no.
Okay. What about in any other particular instance?
Certainly, I've worked for civil rights law firms in the city of Detroit to prosecute the penalty process, and often being aggressive to prosecutor, Detroit police officers, chiefs all across the board. It was successful in a number of convictions.
Okay. So, what does that tell us? That sometimes police are people too, and that
Yes, sir.
sometimes you got good ones, sometimes you got bad ones. So, you do believe you could sit in this particular case, listen to whatever a police officer may say, and judge it like you would anybody else, and decide if you believe it or if you think they're lying or just maybe saw it a little differently?
There's passion for that. I would probably recuse myself from grounds for partiality, but
You would recuse yourself from what?
Impartiality. given the experiences I personally had.
So you think every time you see a police officer that you would not be able to be fair? You're not a fair person. You see a police officer and you would say, hey,
I'm not trying to be,
they're, wait a minute, let me finish. You see a police officer and you're immediately going to say, well, you know what? He's corrupt. He's lying. I don't care what the evidence is in the case. I'm just going to make that assumption. You would jump there.
not always, but it depends on the circumstance.
Well, no, I'm asking without having heard anything, you're already telling me this. So I'm just trying to confirm that you are telling me that you are not a fair person with police. You are already made an assumption that they're all fit into one little bucket and that you are not able to see any difference between one person based upon what they might have done and the other person who might have done nothing. You can't do that.
Specificity, I say I probably could, but I would say that given my past experience, the vast majority I would probably see in a different light than the average individual.
So what does that mean? You probably could, but the vast majority of them you're not going to. That's basically what I'm hearing. That means you can't, doesn't it? Nobody wants to say they're not fair. So you got to tell me I'm not fair.
I would say I would not be fair in that instance, Your Honor.
So you're not going to be fair.
I would attempt to be, but I cannot guarantee that.
So you look at each individual and you make a judgment just on what they do. That's what you're saying. So that you could stretch that to anything. You could stretch it to gender. You could stretch it to race. You could stretch it to religion. And now you're going to stretch it to their job. So the fact that they have a job as a police officer, in your mind, that's enough for you to put them in a bucket of being not credible, liars, whatever the other police have done. Put them all in the same bucket. That's what you.
Just take a moment to clarify.
Sure, go ahead.
Given past experience, post-traumatic stress, given certain situations in my life, I think that would influence it.
Okay, well, tell us about the post-traumatic stress in a certain situation.
I've been assaulted by police officers before, for something I haven't done. I've been in instances where my freedom was compromised, given misunderstandings. It's hard to overcome that. I think it's a very triggering thing.
Okay, so anytime you see a police officer, you think it triggers something in you that you wouldn't be able to even listen to anything they're saying,
It's
basically.
like I said, given circumstances. Yes, Your Honor, I'm not trying to be difficult. Sure.
Okay. Let me ask you if you have any questions for him.
What did you say this traffic ticket was with Officer Chandler?
In the last 10 years, I believe, because I said 7 at first, I'm not 100% sure.
Okay,
I don't think the traffic ticket's the problem. I think it's generally other situations he's faced with police.
yeah, just with the traffic ticket, do you know for sure if it was Southfield PD or Lathrop Village PD?
I'm not sure if it's Southfield 696.
Okay, but you think it was a little bit older, closer to 10 years, 6 or 7 years?
No more than 8, I believe.
Okay. As far as Officer Chandler, I think would be okay because he hasn't been on the force that long, so maybe it is a different Officer Chandler. With regard to your general views, you said you're a political candidate.
Yes,
At what office are you running?
State House,
Okay.
the sister.
And are you running on an anti-police campaign or anything about that?
I don't know.
Have you made any statements to the press or the media or your staff about your views on police officers in the past?
No, I wouldn't say I would. Yeah.
Okay. So in that sense, I guess you're able to be fair to police officers in the campaign sense.
I should, there's a personal and professional life of allow myself to take away my fiduciary obligation to represent constituents in the district.
Okay. So the judge is going to instruct you that you are to take the testimony of a police officer the same as you would any other witness. Would you be able to, just like you do with your campaign, to do the job that you're assigned to as a juror and listen to that jury instruction?
Yes, I'll try to do that.
No further questions.
Mr. McLaughlin?
No.
Okay. Sir, you heard the other questions about burden of proof, reasonable doubt.
Yes, Your Honor.
Anything you want to tell us about that? The concept, does that bother you?
No, Your Honor.
The fact that she has the burden of proving this crime beyond a reasonable doubt? And that if she doesn't, that you have to give a not guilty verdict? Does the fact that the defendant is sitting here not guilty now bother you? Okay. The fact that police officers apparently must have been involved in this matter at some point, does that bother you? Okay. But the fact that you might hear from police officers about their role in this, whether they saw it, heard it, or arrested, that would bother you or wouldn't bother you. Well, what's the potential?
Because I'm actually reporting kind of emotional or, past post-traumatic stress.
Okay.
General.
All right. But you just told her you would try.
I would attempt, yes, absolutely to remain impartial.
Okay.
Just wanted to air that to the report.
Very good. All right. Any challenges for cause?
No, yeah, I remember those.
Mr. McLaughlin?
No.
Okay. Let's see, peripheral challenges on the fence.
Yeah, Judge, we'd like to attention excuse your number 6, Ms. Bragg.
Ms. Brett? All right, we'll have you step down. And to replace Ms. Brett, seat number 6, we're gonna call Ms. Angelelli. And you want to tell us a little bit about yourself and your family when you get settled there?
I'm a retired teacher.
What did you teach?
Well, I was this certified secondary. I taught healthy social studies, middle school. And then after 2 years, I started a tutoring business that I ran for about 20 years.
Oh, what was the business?
It started off as just general tutoring, math, any subject, and then kind of morphed into ACT and SAT.
Ah, good, yeah. I bet you had lots of folks were standing in line for that.
Now I'm officially retired, but I work part-time at a horse farm.
Oh, horse farm. Oh, that's lovely. Lovely, lovely. Okay. What did he used to do before he
I
retired?
was a manager at a grocery store in Royal for many years.
Oh, there's a few of them I like over there, so. Yeah, that's it. The one I like. Okay. All right. Did anything pop into your mind, like he wanted to share it with us right away? Something that you wanted to share right away when you were listening to the questions? Okay. And of course, we already asked everybody, and I think you agreed you still live in a district and all that. Ever been a juror before?
Many years ago, the federal case in downtown Detroit was a drug case. I actually think they plea before
Before you even had to really decide anything? Okay. All right. And so nothing about that would make you feel you couldn't fairly sit in this case. All right. You heard the questions about the burden of proof, reasonable doubt. His burden is on her to prove this beyond a reasonable doubt. And you heard the fact that the defendant is presumed innocent. Anything about those concepts that was disturbing or just a little just disconcerting for you? Okay. And so depending on what you listen, what you decide about those facts, you could either convict or acquit, either way. All right. You got any issues with police officers? Okay. All right. And you know that we're going to tell you to just judge them by the standards you would judge anybody else. Okay. Miss Rosna, I don't know. I'm just going quickly. Did you have anything else that you wanted to ask her?
If you don't have any questions for me about anything I talked about or anything that you wanted to bring up in regard to my questions.
Mr. McLaughlin?
Yes, ma'am. Regarding the charge, obviously this is about threats allegedly made to school staff. Obviously you work in the education system, but is there anything about that touches you the wrong way or makes you feel the wrong way about the case? Do you think you can be fair and impartial in this case?
I think.
Okay. The charge itself does not send any feelings to you one way or the other. Would that be fair? And the judge went over beyond reasonable doubt what that means extensively. We've already heard the instruction about it. I just want to know that you're going to hold the prosecutor burden, which is to prove the case beyond reasonable doubt.
Yes.
Have you ever been part of anything like that in your employment, like someone making a threat or something like that? That would, or anything else you think we should know? Fair enough.
Okay. Any challenges for cause? People?
No, you're.
Defense? Pause, Mr. McLaughlin. Okay. Back to the people for peremptory.
Yes, Your Honor, people would like to thank and excuse juror number 4.
All right, that would be Miss Williams. Well, Miss Williams, you held on for a while. Sorry to have to excuse you off.
Thank you.
Okay. And that was from the prosecution. And we will come to replace her with juror number 10, Mr. Philpott. Yeah, that's fine. You can just hand it to Mr. Philpott. That'll be fine. Okay. Good afternoon, Mr. Philpott. Tell us a little bit about yourself and your family.
Well, retired, postal worker. It's like that.
Oh, where did you serve? What a war? Or was it war?
I was at that, so
Uh-huh.
right.
Yeah.
My wife is, she works for Oak Park Public Schools and Human Resources.
Okay. All right. Any kids?
Yeah, 2. 6 grandkids.
That's a lot. You're busy. They're fun though, because you get to give them back, right? All right. So, anything pop out to you that you wanted to share with us as the questions were being posed?
Pretty much straightforward.
All right. So the concept of her being the prosecutor, having to prove the case beyond a reasonable doubt, all the elements, or you have to quit. You don't have any problem with that? And if she makes her burden, proves all the elements to your satisfaction beyond a reasonable doubt, you'd be able to convict. You have any problem with the idea that the defense doesn't have to do anything? They could just sit there and that they're considered to be, not guilty until she proves her case. You have a problem with that? What about with police? You got a problem with them?
No, I don't have a problem with that.
So you'd be able to listen to anything that they testify to and pretty much judge it the way you would anybody else's testimony. Okay. All right. Schools. Obviously, this is something about speech that was allegedly stated to someone at a school that might have been in a threatening or violent manner. So, do you have any, sense of thought about that kind of behavior that you would think that maybe you would be able to sit as a juror and even listen to hear what might have happened?
Wouldn't have a problem with sitting.
Okay. All right. I know you got kids and then of course grandkids, so I'm sure they've been in a school somewhere. So it just gives you some pause for concern, but not enough to say you couldn't sit and listen to the case. Okay. All right. So all we're looking for is you to be fair for the prosecution and fair for the defense, and you could do that. Okay. Ms. Rosendahl, any follow-up questions?
You don't have any response to any of my questions that you'd like to discuss with me, right?
I know.
Okay, and the judge already touched on whether anything left in your mind at the end, so I don't have any further questions.
Sir, your wife's full employment sounds like not really affecting you one way or the other in this case. Okay. How about what we touched on with regard to free speech? You think we got it about right in this country? You think there should be more restrictions, less restrictions?
So, free speech is free speech.
Okay, fair enough. Is there anything else at all that you think we should know about you? Do you think you could be fair? Do you think you'd be a good judge in this case?
Yeah.
Okay, fair enough. Thank you.
Challenges for cause for the people.
No, you're.
Defense for cause. Challenges peremptory for the defense.
1 second. No.
All right. I think we got a jury. Huh? I think we do. So, unless I think we're.
I do not have any further.
Okay, all right. All right, so ladies and gentlemen, we do have a jury here. And so I'm gonna swear you in. That's good. You ready? Yes. So members of this jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I'm not going to ask you all to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, then you may instead affirm to try the case justly and to reach a true verdict. So please stand, raise your right hands, and the clerk will give you your oath.
Do each of you solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberations, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court?
All right, very well. You can have a seat. And for the rest of you, I certainly want to thank you for being here today. The fact that you came really did assist us. You have now served your jury service for at least the next calendar year, the next 12 months. But you might get some type of a notice to serve at circuit court or either federal court downtown. But we're pretty much won't be summoning you at least for the next 12 calendar months. So some people say this is their first time. They've been here 30 years. They've never been, summoned before. And other people say every couple of years they get one. So it's just the luck or unluck of the draw, whichever way you want to look at it. But we really want to thank you for your service today and note that the proverbial check will be in the mail for your day of jury service with us today. And I think they're still giving juror certificates that you could frame and put on your wall if you're so inclined. If you need something for work, there would be a downstairs at the jury clerk where you checked in. She could give you a little letter, or she might even come up and distribute those in the jury room before you leave. So other than that, thanks so much. And we hope that, you got a little bit of day left that you can enjoy the rest of this. Hopefully it's a pretty nice day out there. So thank you so much for being here. The court officer is going to take you back to the jury room. Maybe one of the other judges might come to say something. I'm not sure. Okay. All rise for these jurors. Thank you. Okay. So everybody may be seated. So when the court officer comes back, he's going to take the rest of you back to the jury room to show you where to check in. This will be a quick lunch break. We're going to just take an hour. We usually take an hour and a half, but I want to get this case to you because I think we can finish this up fairly quickly today if we just get it moving. So at this point, it's like, let's just say 1:35. Let's come back at 2:35. If you're not familiar, and I know most of you are, there's a bunch of restaurants right up and down Evergreen. You can even go home if you want, because usually home's not very far. Just get back at the allotted time of about 2:35, and then we'll be ready to, I'm going to preliminarily instruct you again. And then after that, they're going to start into their case. Okay. So before we go though, there's certain things that you do need to know that you can't do. Let me find those. So you must not discuss this case with anyone, including your family or friends. You must not discuss it even with the other jurors until the time comes for you to decide this case. So when it's time for you to decide the case, I'm going to send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in a jury room when all the jurors are there. You must not talk to the defendant, the witnesses, or anyone else who may be connected to this case. Any of the lawyers as well. That means you may not speak to these individuals, even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to the case. This restriction is necessary to avoid even the appearance of improper conduct on any person's part. So if anyone tries to discuss the case with you or in your presence, please tell them to stop and explain that you are a juror and you're not allowed to discuss the case. If they continue, then leave and report the incident to court staff, which would be in your case, the court officer, as soon as you return to court, and then he'll let me know. And of course, when the trial's over, the restrictions do not apply. So these restrictions that I'm about to describe are meant to ensure that everyone gets a fair trial. So in our system, it's crucial jurors are not influenced by anything or anyone outside of our courtroom. Under the law, the evidence that you consider must meet certain standards. For example, witnesses must swear to tell the truth. Lawyers must be able to cross-examine them. So because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I do discharge you from your jury service. It's your duty as a juror to decide the case based solely on evidence that you see and hear in this courtroom. You must not consider information that comes from anywhere else. So this means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, if there is any, or TV, radio, internet, or on social media platforms. You must not research any aspect of the case during the trial. This means research using cell phones, computers, or other electronic devices to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigations or experiments using internet, cell phones, computers, or electronic devices. You must not visit the scene of any event at issue in the trial. If it's necessary for you to view or visit a scene, court staff would take you there as a group under court supervision. You must not consider as evidence any personal knowledge that you may have of the scene. You must not share information about the case by any means, including cell phones or social media. That means that even if you're not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. So if you discover that a juror has violated my instructions, please report it to the court officer. All right, so that's the instructions to abide by when you're outside of the courtroom. Please keep those juror badges prominently displayed on the outside of your jackets and coats so that people can make sure they avoid you. They know around here not to talk to you. So it's not that they're trying to be rude, they just don't want us to have any appearance of improprieties that could affect any verdict or anything like that. Okay, so now let's go to, took me a little while to read that, let's go to 22. So we'll go to 22 and come back. Okay, so where's Charles? Here he is. Okay. 20 minutes to 2, 20 minutes to 3. You're gonna come back. Yeah, or another way of saying it. Yeah. 2:40. Okay, ready? I don't, well, they're not deliberating yet. You don't have to do it till they deliberate.
All right,
You're all set.
all right, all rise for the jury. Walk this way.
Anything before we bring the jurors in?
Your Honor, one of the jurors, juror number 7, did stop me by standing in front of me outside the courtroom and asked me where he should go. I responded, I'm not allowed to talk to you, I'm sorry, and I moved past it, so I just wanted to put that on the record.
After we told him not to talk to anybody. Uh-huh, yeah. Well, that's not enough to disqualify him. So he's staying despite any of his efforts,
I think, yeah.
because that's what he's doing.
And then, Your Honor, just given the time, I'm hoping we can complete this today. I do want to make the court aware that I have an appointment this evening. I need to leave by 5:30 at the latest, so I hope that we can conclude. by-
I don't think you're gonna conclude it by 5:30 because they gotta deliberate. So that means, because why would you have an appointment on jury trial day?
I'm on a board that meets the second Tuesday of every.
Because I had an appointment and I had to cancel mine yesterday.
Unfortunately, they meet the second Tuesday of every month, so last jury trial day, I left court, spent there, was still late, and then I didn't eat dinner till 10 o'clock. And it's just, it's not something that I can keep up. I've also been told by my office that we should be leaving by 5 o'clock.
Well, that's, you know what, your office don't run my courtroom.
I know. And
So I'm sorry, but this is the way we work in this particular court. We will stay till 6 because our jurors don't want to come back. Usually they want to continue to deliberate. So if you can get your proofs done and you want to send somebody to take the verdict, you can do that. But otherwise, we go in until we can finish.
Thank you.
I canceled my appointment. I just gave up. Second.
If it were something I could cancel, I definitely would.
Oh yeah, I cancel board meetings too. I just don't go. I can't cancel them.
Yeah.
I just don't go.
This particular meeting is something that I'm highly involved in.
All right, but we'll see what we can do.
Thank you.
Mhm. Mhm. Okay. So that means everybody has got 5 minutes on their closing argument, if that's the case, if we get that far, which I doubt we will. But I expect it to be short. No, like the voir dire was too long. We're not doing that for closings. We're gonna shorten this thing up. So you complaining about leaving, we're gonna get it out. We're gonna get it done. It's gonna take more than 5 minutes to sum it up. That's the way I'm figuring, and I'm gonna time it. Okay, so when they come, I'm gonna start with the instructions.
Okay, all rise for the jury.
Mhm. All right, the record shall reflect that all 7 jurors are in this courtroom and seated in their respective seats. Everyone may be seated. And so, ladies and gentlemen, we're going to continue with the other preliminary instructions. So, and you're going to receive a copy of the final instructions at the close of the trial, as they will potentially change or get added to at least during the course of the trial. So I'm going to explain some of the legal principles you'll need to know in the procedure we're going to follow in this trial. So the defendant is charged in count 1 with the intentional threat to commit an act of violence against the school employees, or students. To prove the charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant made a threat. Second, that the threat was stated verbally or through the use of an electronic device or system, or through some other means. Third, that the threat involved the use of a firearm, explosive, or other dangerous weapon to commit an act of violence against any students or school employees on school grounds or school property. Fourth, that the defendant made the threat intentionally, meaning that she did not do so by accident or mistake. Fifth, that the threat could reasonably be interpreted as harmful or adverse to human life or dangerous to human life. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about October 24th of 2025 within the city of Southfield, County of Oakland. Now, a person accused of a crime is presumed to be innocent, and this means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. And every crime is made up of parts called elements, and the prosecutor must prove each element of the crime beyond a reasonable doubt. So the defendant is not required to prove her innocence or to do anything. So if you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt, growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that's reasonable after a careful and considered examination of facts and circumstances of this case.
Let your attorney know it.
So a trial follows this procedure. First, the prosecutor makes an opening statement where she gives her theory about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes hers, or he may wait until later. These statements are not evidence. They're only meant to help you understand how each side views the case. So next, the prosecutor presents her evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of her evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove her innocence or to produce any evidence. If the defense does call a witness, the prosecutor has the right to examine them or cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, and the prosecutor and the defendant's lawyer will then make closing arguments. And like opening statements, these are not evidence. They're only meant to help you understand evidence and the way that each side sees the case. And you must base your verdict only upon the evidence. So my responsibilities as judge in the trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies in this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinion about the facts of the case. As jurors, you are the ones who will decide the case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes what you believe and what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of the case are is to decide which witness you believe and how important you think their testimony really is. You do not have to accept or reject everything that a witness says. You're free to believe all, none, or any part of a person's testimony. And deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice that you may have based on the witness's race, national origin or ethnicity, gender, gender identity or sexual orientation, religion, age, or socioeconomic status. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these things. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the question or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or personal interest in how the case is decided? Have there been promises, threats, suggestions, or other influences that affect how the witness testifies? So in general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does that witness's testimony seem when you think about all the other evidence in the case? So when it's time for you to decide the case, you are only allowed to consider evidence that was admitted in the case. So evidence includes only the sworn testimony of witnesses, exhibits admitted in the evidence, and anything else that I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. And you should not think that something is true just because one of the lawyers asks questions that assumes or suggests that it is true. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask a question, my only reason would be to ask about things that may have not been fully explored. During the trial, you may think of an important question that would help you understand the facts in the case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished the questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to the court staff, which would be the court officer, who would then give it to me. Do not show your question to the other jurors. If your question is not asked, it's because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusion or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, that you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on the objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinion about the facts of the case. Sometimes the lawyers and I will have discussions outside of your hearing. Also, while you are in the jury room, I may have to take care of some other business matters that have nothing to do with this case. So pay no attention to these interruptions. You must not discuss the case with anyone, including family or friends. You must not even discuss with other jurors until the time comes for you to decide the case. When it's time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all jurors are there. You must not talk to the defendant, the lawyers, or anyone else, including witnesses that are connected to this case. This means, and I heard that someone tried to say something to one of the lawyers today, and that's not appropriate, and I've told you not to do that. You should not speak to any of these individuals, even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to the case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you're a juror and that you're not allowed to discuss the case. And if they continue, leave and report the incident to court staff as soon as you return to court. When the trial is over, the restrictions will no longer apply. And when the trial is over, you may, if you wish, discuss the case with anyone. During the trial, of course, do not read, listen to, watch any newspaper reports. Under the law, evidence that you consider to decide the case must meet certain standards. So, for example, witnesses must swear to tell the truth. Lawyers must be able to cross-examine them. Because news reports do not have to meet those type of standards, they could give you incorrect or misleading information that might unfairly favor one side. So, to be fair to both sides, you must follow this instruction. So, again, these restrictions that I'm going to describe are meant to ensure that all parties get a fair trial. So in our judicial system, it's crucial jurors are not influenced by anything or anyone outside the courtroom. And of course, I just talked about the standards that evidence needs to meet. So these restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide the case based solely on evidence you see and hear in the courtroom. You must not consider information that comes from anywhere else. This means until you deliver your verdict, you must not read, watch, listen to, receive any information, including opinions or commentary about the case, whether in newspapers, TV, radio, internet, or on social media. You also must not research any aspect of the case during the trial. This means research using cell phones, computers, electronic devices to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cell phone, computers, or other electronic devices. You must not visit the scene of any event at issue in the trial, and if it's necessary for you to view or visit that scene, court staff would take you there as a group under court supervision. You must not consider as evidence any personal knowledge that you have of the scene. You must not share information view or visit that scene, court staff would take you there as a group under court supervision. You must not consider as evidence any personal knowledge that you have of the scene. You must not share information about this case by any means, including cell phone or social media. This means that even if you're not discussing the case with someone else, you may not post any information about it on social media websites or in any other kind of manner. If you discover that jurors have violated those instructions, report it to court staff. You may take notes during the trial if you wish, but of course you do not have to. If you do take notes, you should be careful that it does not distract you from paying attention to all of the evidence. When you go to the jury room to decide the verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except other jurors see them during your deliberations. Of course, your notes will not be examined by anyone, and when your jury service is concluded, your notes will be collected and destroyed, and the court officer will collect them and shred them. You can see that we have chosen a jury of 7. So after you've heard all the evidence and my instructions, we will draw lots to decide which one of you will be dismissed to form a jury of 6. Possible penalty should not influence your decisions. If you find the defendant guilty, it's the duty of the judge to fix the penalty within limits provided by law. I may give you more instructions during the trial, and after the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules that apply and the law that applies to this case. And you should consider all of my instructions as a connected series. Taken all together, they are the law that you must follow. And after my final instructions, you will go to the jury room to decide on your verdict. And a verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It's important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decisions. Each of us may have biases or perceptions about other people based on stereotypes, and we may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. So take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of other jurors who have different backgrounds and perspectives from yours. All right, so those conclude the instructions for now, and we will pick up at the end of the case with some additional instructions. So now we're going to move on to the opening statements. People.
Words matter. When those words contain threats of violence against schools, those words matter even more. The evidence will show that on October 24th, 2025, the defendant, Octavia Miles, called her daughter's school, which was the Alice M. Burney K-8 school, and made a threat over the phone to come up to the school and shoot it up. You will hear today from 4 witnesses for the people. Ms. Tessmalia Tansel will testify about the phone call that she received while she was working in the front office that day and the words that were said to her over the phone. 2 school administration officials, Mr. Matthew Enox and Ms. Kimberly Pritchett, will testify next about their interactions with the defendant that day and their later interactions with the Southfield police once the threat was brought to their attention. Finally, Southfield Police Officer Chandler will testify about his investigation, how he went to the home of the defendant, conducted a search of the residence to search for a firearm, and thankfully no firearm was found. But that doesn't excuse that a threat was made, because words matter. As the judge has already instructed you, this crime is made up of elements, and those elements are first, that the defendant made a threat. Second, that the threat was stated verbally through the use of an electronic device or system or through other means. Third, that the threat involved the use of a firearm or other weapon, in this case, a firearm, and that it was made against students, school employees, on school grounds or school property, that threat of violence. Fourth, the people will need to prove that the defendant made the threat intentionally, meaning she did not do so by accident or mistake. And finally, the people will need to prove that the threat could reasonably be interpreted as harmful or adverse to human life or dangerous to human life. I must prove each of these elements beyond a reasonable doubt, and I ask that you please hold me to my burden. We've discussed a lot about what that means, reasonable doubt, so I won't bore you with that again. I believe the evidence will show at the conclusion of the trial that the defendant should be guilty. Thank you.
For the defense, Mr. McLaughlin.
Here are the people outlined, a kind of basic case of what this is going to be about. This is going to be about one person saying one thing to another person. That's what it's going to be. You heard the four witnesses, what we anticipate the testimony being, or what the people seem to anticipate the testimony being, is that it involves a statement of a shooting or the word shoot. Okay, some variation of that. From one witness on the phone. This is significant because, as the people said, words matter. So the word in question is what matters here. All right, because as the people showed you through the instructions, the threat of using a dangerous weapon is what is at issue here. You can be mean, you can be nasty. This is America. You can say all kinds of nasty things. You can say nasty things to a school official. You can be angry. Okay. And in this case, you're going to hear likely this involved in a situation where Miss Miles' child is allegedly being bullied. There's a dispute about that, how that's being handled at the school, and people are hot-headed. And there's a hot-headed disagreement from Miss Miles and the school administration. But the question is the word that she used shoot? Did she threaten to shoot the school? That's the issue. Okay. And the words do matter. And how do we tell whether or not someone's accurate about what they recall or what they heard? Well, you tell in part by their action. And what you're going to see here is actually a decided lack of evidence. Okay. And the thing to remember here is when we talk about school shootings and alleged allegations of people saying they're going to shoot a school or whatever, this is a hot button issue that everyone's afraid of, right? It just is. Everyone in the community is afraid. Everyone's got a kid is afraid. We all know about Oxford, what happened up there. This is a situation that people are on eggshells about. If they get a whiff of something dangerous happening at a school, everyone's going to lose their minds. The school's going to lose their minds. The police are going to lose their minds. Everyone's going to be very concerned, and they're going to act and overact in correct in anticipation of that to prevent another hostage from happening. This is significant because at some point, everyone's fear and this area around it starts going in the other direction. We start pushing against other people's rights, right? That's part of the issue here, because everyone's so afraid. The school's afraid, the police are afraid, the police don't want this to happen, the school doesn't want it to happen, everyone wants to prevent this, and everyone's going to go over and above to make sure it doesn't happen. The problem is, in this case, what you will see is that there is a decided lack of evidence. There's a statement from one person over the phone. That's it. You're not going to hear any recordings. You're not going to see any surveillance tape. You're not going to hear any follow-up investigation. You're going to hear that the police went to Miss Miles' house and arrested her for this crime without even speaking to a witness who allegedly heard the statement, because they are that concerned about it. You're going to hear that the school administration was volunteering what other people heard, and the police took it as gospel and started making arrests, because they are that concerned about what would happen if they didn't do that. You're going to hear that the statement that was allegedly made didn't come out until hours afterwards. You're going to hear that Miss Miles actually went personally to the school after allegedly making a statement that she was going to shoot the school. That she went there, that she had a whole interaction with the staff there, that this happened over the course of hours, that she went home, and then hours after the fact this gets brought up. So when we ask yourself the question, how reliable is this statement? How reliable is this testimony that they believe the word shoot was said? Well, you can judge that based on their own action. And what you're going to see is there's not a single action that anyone took at the time this allegedly was said that would show that they believe that that's what was said. There's not one action. Their story is not going to make any sense because they sat on this for hours. They allowed Miss Miles to come up to the school. They didn't do anything then. They did it hours later. And they're going to ask you to turn around and say, well, you should believe this person beyond a reasonable doubt. The beyond a reasonable doubt standard. That is sacrosanct. Because when you have a situation like this, where people are on edge, people are nervous, people want to protect the schools, and they should, people start jumping. They start skipping steps. They start encroaching on people's rights. They start making arrests without evidence. They start making arrests without talking to witnesses. They start calling hours later after the fact to make reports. Because they all want to cover themselves and no one's really concerned about what the truth is. The police want to cover themselves, the school staff wants to cover themselves, but people are less concerned about what the truth is and more making sure that they are covered. That's what this is about. And ultimately, what you're going to hear is that the facts and evidence don't show that there was any belief by anybody that these statements were true. Because if they were, Ms. Miles never would have even made it up there. And I ask you to find the defendant at the end of this case, not guilty. Thank you.
All right, thank you, Mr. McLaughlin. Call your first witness.
People call Miss Cecilia Tansen, and I will step on a different.